Good morning. Like prosecution, criminal case, civil case, the another field was that administrative law. There we have to face departmental inquiry. Normally, whether it is central government employee or state government employee, there shall be two category of punishments. Number one, minor punishment. Number two, major punishment. For minor punishment, even censure, admonition will be considered, or one day salary fine. These things will be minor punishment. Major punishment will be removal from service, depromoting, withholding pay, so many things. So far minor punishments are concerned, a preliminary inquiry will be there, ordinary summary inquiry will be there. So far major punishments are concerned, initially they may hold preliminary inquiry, thereafter they will suspend, and thereafter memorandum of article of charges will be issued like charge sheet, and that will contain the imputation of allegations, documents, witnesses relied, all these things, and show cause notice will be there. You have to explain your show cause notice. Then they will appoint enquiry officer. For enquiry officer, you may have objection for that. Thereafter, there will be a enquiry officer and presenting officer on the behalf of the department, like prosecutor, and you can have your own assistants, departmental employee, to assist you to defend your case. But after the notification of Advocates Act, our endeavor was that even advocate may be allowed to represent the delinquent employee. But here another case is there the Supreme Court has come to rescue with the great citations. You kindly see, this is most important citations. Therein, there are two concepts. Though the departmental employee did not excise that, but still the ratio is there. Kindly take AR 2022, Supreme Court 582, Chairman State Bank of India, and another versus M.J. James. They have defined a bank and give ratio. Then they say natural justice, Article 311(14). Right to be represented by counsel or agent of one's choice is not absolute right. They say it is not absolute. It can be controlled, restricted, or regulated by law, rules, or regulation. This is next thing is most important. If charge is of severe and complex nature, then recused to be represented through counsel or agent should be considered. This is what they say. Here actually they have the employee was dismissed from service. The High Court has set aside because some principle of natural justice were violated, but however Supreme Court set aside the High Court order because there was a laches. The behavior of the employee was not to the standard. He slept for years together. Then another for these postgraduate students, doctrine of acquiescence, distinction between acquiescence and delay and laches. Acquiescence is a equitable doctrine where you have power, you have right, you have privilege to exercise certain things, and you remain silent. That means you acquired that as not willing to accept it. This is what it says. Kindly go through this, and thereafter the departmental inquiry. If central government servant, you can go to central administrative appeal first, appellate authority first. There is a revisional authority, then the revisional authority, then statutory revision is there under the act, wherein you have under the act or under the rules where you are being departmental hold responsible. If there are sumoto revision, you need not, then you can go to straight away. If central government servant, you can go to central administrative. If it is paramilitary forces, you can go to High Court. If it is military forces, you have to go to Army tribunal. If it is not within those category, if it is government employees, then you can go to writ petitions after exhausting your appeal and revision rights. Thereafter, what actually happen if you are a private employee, if you are not within the definition of management, if you are within the workman, you can raise your dispute before the Industrial Dispute Act. There are Industrial Dispute Act before the Labor Court, and the Labor Tribunal is meant for the enforce rights of the labor union leaders. These are the two labor laws. That is one of the administrative. The main doctrine used in the administrative law was that armchair policy, doctrine of armchair policy. That means the authority who interfere with the administrative order should not sit as administrative authority. He has to only look into the matter only on perusal of records. If there are grave error on the appearance place of the record, or principle of natural justice was violated, or then perverse finding and contrary to the records available, and ipsi dixit, the court cannot give its opinion which were not there on the records. These all are the doctrines for administrative law. I hope you understand these things.